Removing a CEO from a private company is a complex process that requires careful legal and strategic planning. Whether due to poor performance, misconduct, or a change in company direction, understanding how to legally and effectively oust a CEO is essential knowledge for board members and shareholders. The CEO serves as the company's leader, accountable to three key groups: investors who expect profit and results, employees who need motivation, and customers who demand satisfaction. This challenging position often commands significantly higher salaries than other roles within the organization. CEOs operate under contracts with terms determined by the company's board, though their work arrangements can vary widely from hands-on management to minimal direct involvement. Several legal grounds exist for removing a CEO. These include breach of fiduciary duty, where the CEO acts against company interests through self-dealing or conflicts of interest. Financial misconduct such as fraud or embezzlement provides clear justification for removal. Poor performance, consistently failing to meet company goals, can also warrant dismissal. Loss of board confidence or pressure from major shareholders seeking leadership changes are additional valid reasons for CEO removal. Before initiating any removal process, it's crucial to review the CEO's contract, corporate charter, and shareholder agreements that outline dismissal procedures. These documents establish the framework for legal action. The balance of power between shareholders and the board determines how a CEO can be removed. In most private companies, the board of directors has the final authority to remove a CEO through a majority vote. Majority shareholders can exert significant pressure on the board to take action. Some shareholder agreements may even provide direct authority to vote on CEO dismissal, bypassing the board entirely. Interestingly, even company founders aren't immune to removal. Steve Jobs was famously pushed out of Apple for a period. As companies grow, founder ownership often becomes diluted below 50%, making them vulnerable to removal if they fail to properly manage the organization's growth. There are several strategic approaches to removing a CEO. One method involves overwhelming them with responsibilities beyond their capacity, potentially by removing supportive figures like the chairman. Another approach creates an environment where the CEO feels underqualified and threatened, leading to poor team selection and ultimately poor results. Undermining a CEO's image by providing inaccurate information can lead to bad decisions that justify dismissal. For new CEOs, keeping a former CEO within the organization can create divided loyalties among employees, undermining the new leader's authority. The actual process of ousting a CEO follows several key steps. First, assess the legal grounds and documentation by reviewing the CEO's employment contract and corporate bylaws. Next, build board consensus through discussions about CEO performance and secure majority approval. Engaging legal counsel is essential to ensure compliance with corporate governance and contract law. Once the decision is made, notify the CEO in a private meeting and negotiate terms including severance packages and transition responsibilities. Then announce the leadership change to employees and stakeholders while appointing an interim CEO or beginning the search for a replacement. Finally, mitigate risks and ensure business continuity by offering fair severance to prevent lawsuits and securing company assets and confidential information. Several legal risks must be considered when removing a CEO, including potential wrongful termination lawsuits, breach of contract claims, and shareholder disputes. The timeline for CEO removal varies based on the company's governance structure, ranging from weeks to months depending on legal and procedural complexities. Understanding the proper procedures for CEO removal protects the company's interests while minimizing legal exposure. With careful planning and appropriate legal guidance, the transition can be managed effectively, ensuring the organization continues to thrive under new leadership.